Hello everyone, this is your favorite channel, that is StudyIQ IAS English, and I'm your educator Praveen Mishra, welcoming you all in this session where we are going to discuss about the doctrine of severability. So in the previous lecture we discussed about the doctrine of harmonious construction, and here this time it is about the word severability. So what is this doctrine? Let's discuss the features. So as per the theory, let's say there is a particular law which is having, for example, 5 provisions or the 5 points, and somehow it happens that point number 4 and 5 of the law is considered unconstitutional, or they type of violates or abridges any of the provisions of the constitution. So what we shall do? Shall we consider the whole law with all of those 5 points as unconstitutional and declare it as null and void? No. As per the doctrine of severability, let's remove only those provisions which are unconstitutional and let the other 3, that is point 2, 3 as per the example, to be in force. So once again, so there is a law which is having 5 provisions, out of which 2 of them, that is 4th and 5th part of that particular law, violates or infringes any of the fundamental right or any of the provision of the constitution. Then what we can do is we can just eliminate that damaged part, okay, that is 4th and 5th point, and the other rest, that is 1, 2 and 3 that is left, we can use it. Like for example, we can understand, let's say we purchased this car, and after purchasing the car we realized that the tires, they are not good enough, the tires are not fine enough. So what we shall do? Shall we throw away the whole car or shall we replace the whole car? No. What we can do is we can just do away or just replace the tires. The car remains the same, just the tires, they are changed. As you can see here, this is what doctrine of severability is. Let's say I purchased this car, and after purchasing I realized that no, I'm not satisfied with the tires. Okay, so what I can do? I can just throw away the whole tires, the whole cars, okay, or I can go ahead and replace the whole car, or I have got the option. I can just throw away the older tires, okay, and replace them with the new ones, right? So this is what exactly the doctrine of severability is. So if there is a particular statute, and in that statute there are multiple points, and some of those points of the very same statutes, they violate any of the provisions of the constitution, then what we need to do is, we need not do away with the whole of that statute, just we need to do away or undo those particular provision of the statute which violates, infringes or abrogates any of the fundamental right or any of the other provisions of the constitution. Right, so constitutional basis when we talk about. So the doctrine is not explicitly mentioned. Okay, remember, the doctrine is not explicitly mentioned in the constitution. No, neither of the doctrine that is actually mentioned in the constitution. Okay, but it has been evolved through judicial interpretation, primarily in the context of Article 13, that is the definition of law. Okay, that is Article 13, Clause 1 and Clause 2 specifically. What it says that any law inconsistent with or in derogation of the fundamental right is void to the extent of inconsistency, not necessarily void in its entirety. Okay, so this phrase, to the extent of inconsistency, forms the textual basis for the doctrine of severability. So what Article 13 says? Any law which is inconsistent with the fundamental rights, okay, or it is in derogation of fundamental rights, is void to the extent, okay, to the extent of inconsistency, not necessarily void in the entirety. Okay, void into the extent of inconsistency, not into the extent of entirety. Okay, so let's say these are basically 3 points, okay, or let's say 4 points of particular law, and 2 points are violative, but the other rest 2, they are correct. So what we will do, we will just do away with this last 2 points and the first 2 points shall continue. So this is basically in general the doctrine of severability. And landmark judgments related to the doctrine of severability. As you can see here, these are the judgments which are not very much discussed or debated, but yes, we need to have this in our insights, right? So here we go. The first one, that is RMD Chamarbagwala versus Union of India case 1957. Okay, a law regulating competition was partly challenged, holding Supreme Court applied the doctrine of severability. So what is the name of the case? RMD Chamarbagwala versus Union of India 1957, and the other one, that is one of the most discussed one as well, that is the Minerva Mills case. Minerva Mills versus Union of India 1980. Okay, here also the basic structure came into the picture. Okay, and it stated, Supreme Court, that doctrine of severability should be kept into the picture. That is, simply speaking, a particular law having 4, 5, 6 provisions whatsoever, and 1, 2 or 3 provisions of the law is violating the Constitution, then it's better to eliminate those particular provisions that is violating the Constitution rather than eliminating the whole law. Right, so guys, this is about the doctrine of severability. Thank you so much for watching, and you need to subscribe to the StudyIQ IAS English channel so that you never miss an update from the channel. And apart from that, if you want to connect with me, so we can connect on 2 different platforms. So you can search me on Telegram with the channel name study_with_Praveen. And you can search me on Instagram with the username Praveen Mishra _2107. So wherever you wish to connect, you are free to do that, guys, and ping me up. Let me know what are your doubts and how can I help you. And I assure you something, that earliest possible time, okay, as soon as possible, okay, I will respond to you, and I will surely try my best to whitewash your doubts, to wash away your doubts basically. Okay guys, thank you so much once again. See you soon in the next session. Good day, take care, Jai Hind.